Hi guys, my name is Umar Sheikh and welcome to the YouTube channel of Australia Immigration Matters. In today's video, we are going to talk about the challenges people face during their Australian immigration journey and the most commonly asked questions related to EOI submission, skills assessment process, documentation related to visa lodgement, and the reduced nomination allocations given to states by Department of Home Affairs in the current financial year. So let's dive into the video. If you are going for an additional skills assessment for another ENSCO code and you have got the work experience related to that ENSCO code as well, then you should definitely go for its relevant skill employment assessment as well. So your both of your skills assessment should be equipped with qualification and employment assessment and you will be able to submit the expression of interest for both profiles. Yes, you have to consider, you have to mention the same date which VETSS has given to you in their outcome letter, and that's going to be your start of employment. So the date deemed skilled will be your start of employment, and the number of years they have assessed will be your EOI number of years. You cannot claim the time period before the date deemed skilled in your EOI. The important thing is that which skills is actually obviously it varies from assessing authority to assessing authority, that whether you need to go for whether you need to mandatorily go for the work experience assessment or not, or you need to get your qualifications assessment. But it's always recommended to go for the relevant skilled employment assessment, or you can call it work experience assessment from your assessing authorities. The reason is that the Department of Home Affairs or even the state during the nominations phase would trust on the assessing authorities assessment if they have given you positive assessment and if they have you advised with the experience points. The documents which are required for work experience assessment. Typically it also varies for each assessing authority, but the common documents which are required include employment contract or job offer letters or appointment letters, but should be duly signed by both parties, employer and employee. Then you need employer reference letter for each of your last jobs and current job. Employer reference letter is also called statement of service. It's also called employer testimonials. In different skills assessing authorities have different terminologies, but we can call it simply employer reference letter. So employer reference letter has a specific template, and you can download that template from of statement of service from the VETSS website, and it's also published in our group in the files section. So the statement of service or the employer reference letter is the key document, to be honest. It includes your job title, your working hours, your annual or monthly salary or earning, and your your working manager, your working hours, your job duties, and those job duties should be aligned to your nominated occupation. It is very important, and I wanted to touch it as a topic that the reasons of negative outcome is mainly because of the JDs. If your JDs are not matching with the nominated occupation, then you might have chosen a wrong occupation or wrong profession, or you might have not mentioned your job duties in the statement of service or the employer reference letter correctly. So that is the second thing. And the third important document is the pay slips. You have to submit your pay slips which fulfills the criteria of the payment evidence. So at least you should give two payment evidences. One is pay slip and the other is bank statement. And there are other payment evidences as well. If you cannot fulfill the requirement of bank statement, then you have to submit salary certificate, tax return documents, annual tax deduction certificates, provident fund, or even the superannuation statements. That could work. But the primary documents are four for skills assessment: employer reference letter, employment contracts or job offers, pay slips, and bank statement. And this should cover your whole employment tenure from start to end. That would help you to get positive skills assessment from your relevant assessing authority. A few states like Queensland or South Australia, they don't entertain the EOIs having, they don't entertain duplicate EOIs, or they don't entertain double EOIs for different subclasses. So they have clearly mentioned on their websites that if you are interested for both subclasses, you should include both subclasses in a single EOI. Whereas NSW is concerned, you can submit separate EOIs for 190 and 491. For Victoria, obviously you can only submit for one of the subclasses because it only allows one subclass ROI. And similarly for the Canberra metrics, you can submit Canberra metrics for both 190 and 491 in parallel, along with two separate EOIs, or even a single EOI can serve for both Canberra metrics. So similarly for Western Australia, you can submit two separate EOIs. So it all depends on from state to state, and obviously you have to go through the state's websites to understand this requirement. If you cannot delay your marriage, then you should get married first, and then you should update your expression of interest from single to married status along with your partner points. So you cannot get married after receiving a pre-invite. As I mentioned earlier during my session, that it's a very, very critical condition. You have to prioritize. You can prioritize your marriage and then update your EOI, and you can pause for a while, because your age your age points are going to be the same until 32 years old. So you can wait for a while and get married, and then apply as a married applicants for in your expression of interest. That I would say, if you cannot delay this. There are 3 states which require funds declaration. Number 1 is Queensland, number 2 is ACT, and number 3 is Northern Territory, NT. Northern Territory and Queensland have mentioned on their website the funds declaration requirement, along with the exact values which have to be shown in your bank account or through your assets. Whereas the ACT is concerned, they haven't mentioned any values, but we can consider the proxy of Queensland or Northern Territory regarding this. NT only asks for the funds declaration from offshore applicants, whereas the Queensland asks for the funds declaration statement from both onshore and offshore applicants with different total asset values. ACT only asks for the funds declaration form signatures. They assume that the migrating applicant knows that how much funds would be required to settle in Canberra or in the other regional areas of ACT. So they just get the declaration that you are aware of this, and you will manage the settlement cost while you are migrating. So these 3 states require the funds declaration statement, or you can say you have to sign and submit the funds declaration. There are many occupations which are there in their priority list, but obviously states have their own priorities, and the Jobs and Skills Authority has conducted a survey based on which they have created that top priorities list of 2023. But you have to keep in mind that the states and the Department of Home Affairs, the way of working of these bodies, these states, these governments are different from the independent authorities which are advising the government on the jobs and skills requirement of the economy, Australian economy. So if an occupation is even if an occupation is in the top 10 jobs and skills priority list, it doesn't mean that it has a priority in the eyes of state. States have their own way of working, their own criteria. They are prioritizing healthcare, teaching, and community services and ICT unconditionally over the finance occupations, over the other occupations and engineering occupations. So they have their own system, so you have to follow that as well. South Australia has mentioned it on their website in their important notes section that if even if you haven't submitted an EOI of 491 and you have just submitted an EOI of 190 and your occupation is required at a higher points, or your occupation is required in regional, they can still consider you through subclass 491 for subclass 491 visa. I have heard that Tasmania also does the same thing, that if you submit an EOI and they can see that whether you have better chances for 491, and they can give you invitation for 491 instead of 4190. It's a behavior by few states, but not in all the cases. They are going to continue with the current allocations quota during this financial year. They are going to fulfill that quota. They are going to send a lot of pre-invites, and there would be chances that some of the pre-invites would be wasted during the nomination approval stage. And obviously, in some cases like Western Australia, they have given a lot of pre-invites during their invitation round this month, and and they have given duplicate pre-invites to people who were eligible for graduate stream as well as for the onshore stream. So some of the pre-invites would be wasted, and then they would be conducting another round in a couple of months. So the future of state nomination allocations would remain the same. It would be slow, it would be very, very picky, and they would be prioritizing the priority occupations, critical target sectors, and fulfilling the 10,000 or so allocations for 190 and similar for 1491. While the overall migration program, if we consider the overall migration program, so it depends a lot on the migration system overhaul. Let's hope for the best that the migration system overhaul comes out as a beneficial system for everyone, offshore, onshore, and for all the occupations. And once it settles down, the next financial year is going to be a better year with respect to the invitations and the speed of invitations and the processing times of the visa, which is again a big pain point for some people who are waiting for their visa from like 1 year or so and still haven't got the visa granted. So we hope that the migration system overhaul of Australia by Department of Home Affairs would be beneficial for everyone who are intending to migrate to Australia.